Hello, this is social media attorney Mark Fiedleholtz, and thank you for listening to my podcast, What You Must Know About the New Federal Social Media Policy and Training Standards. Let me start off this podcast with a few revealing statistics. 99% of over 600 decision makers that My Digital Media Institute polled recently, which, by the way, included very competent in-house attorneys, were totally unfamiliar with the new federal social media policy and training standards. Here's another statistic. Out of over 3,000 public and private sector professionals who took my 6-question basic social media law pretest, the average score was 13%. This dangerous knowledge gap is leading to public and private sector organizations unknowingly placing blind trust on model or defective model social media policies from trusted national associations, policy services, and other reputable organizations. For instance, here's another statistic. Out of over 100 social media policies I personally updated recently that all originated from trusted organizations, not one single policy complied with the federal drafting standards. Now, this policy oversight was especially prevalent in the drafting of policies on employee personal use of social media, which is a critical part of your social media policy. New federal standards require specific language on policies relating to employee personal use of social media. Let me give you some perspective. I had to insert the new federal language on employee personal use of social media in every single policy that I updated. And if I didn't do that, the policy would have failed in court. So this is why that I felt strongly it was so important to do this podcast. It's not something I really could explain on the phone, and I think it'll be done in a better way through the method of a podcast. So let me give you 5 key takeaways from the new federal social media policy and training standards that hopefully will motivate you to quickly seek expert help to update your policies and employee training. All right, here's the first takeaway. The first takeaway is to remember that social media liability is predominantly a federal issue, not a state issue. Most social media related lawsuits are litigated in federal court because you're dealing with serious constitutional issues and civil rights. 100% of the hundreds of social media policies and training programs my institute researched recently use vague boilerplate language and only set minimum standards. And a lot of the times that was state minimum standards. The policies made the fatal mistake of citing only minimum state standards and not the federal standards. And I got to tell you, in federal court, this type of error is irreversible and will normally invalidate the policy. So keep in mind that there is also a legal concept known as the preemption doctrine, which draws its legal authority from the Supremacy Clause in Article 6, Clause 2 of the United States Constitution. The clause states that federal law preempts state law, and the state law is declared invalid, especially if there's a conflict. In the context of our conversation, now this is significant. If your social media policy only includes minimum state standards, not the federal standards, as stated before, you have no chance. The policy will be ruled invalid and you'll be left vulnerable. All right. So therefore, you must verify that your social media policy reflects federal law, not state law. Also, you need to ask the organization who wrote the model policy you're relying on if the policy drafter was written, or if the policy drafter rather was a social media attorney specialist, not a general attorney or employment law attorney. That's just not going to cut it. All right, let's move now to the second takeaway from these new federal social media policy and training standards. In the second takeaway, I want to cite one of the biggest mistakes you can make under these new federal standards. Too many organizations continue to mistakenly view the development of social media policies and employee training as a public relations or marketing issue instead of being a high-risk human resource topic. This misperception has resulted in the use of defective social media policies and employee training that trigger costly lawsuits, decision-maker personal liability, it's destroyed employee careers, and you lose public trust. Courts have ruled in both public and private sector cases that the viral capability of social media makes social media an inherently dangerous broadcasting platform. That's a really important concept for you to embrace. Unmonitored employees can weaponize their personal social media accounts to send posts that cause permanent reputational damage worldwide. Therefore, it is urgent that you have a social media attorney specialist like myself review and update your social media policies and design your employee training programs. For the legal authority on this issue, I highly recommend that you read the 2017 U.S. Supreme Court landmark case of Packingham versus North Carolina. The cite on that, or the citation, was 137 S period CT period 1730. Now, that's a public sector case. And in the private sector, I would definitely visit the National Labor Relations Board website and research recent social media policy decisions. All right, let's move to takeaway number 3 from the new federal policy and training standards. So number 3, now that we know the court views social media as an inherently dangerous broadcasting platform that can permanently destroy a person's reputation worldwide, you cannot just tell employees to use common sense and read your social media policy. Verbal pronouncements to your employees are going to come off as, especially in court, as just a doing training on the cheap and not really caring about this issue, not taking it seriously. And that's all about foresight. And then again, when you have negligent claims, you want to prove that you have foresight, right? But here's the key. You must enforce your social media policy with outside expert social media liability training. Your social media policy is going to lose its force without being underpinned by expert training on the new social media speech laws. Courts consider it negligent for any organization to promote the use of a powerful medium like social media and then leave your employees inadequately trained. This lack of knowledge inevitably will lead to costly social media speech mistakes and damage your public image. So I would strongly recommend that you read the 1998 U.S. Supreme Court companion cases on this issue of Burlington Industries, Inc. versus Ellerth. The cite on that is 524 U.S. 742, and Farragher versus City of Boca Raton, 524 U.S. 775. Really important cases. Now, although these cases involve workplace sexual harassment, the court's ruling can be applied to social media as well. The U.S. Supreme Court stated that on high liability issues, if you want to proffer an affirmative defense, if you really want to put up a strong defense, you cannot just have a written policy. You must give employees more in-depth training. Remember now, these employees can weaponize their personal accounts, especially on social media. They're reaching millions and you can never get it off. It's permanent reputational damage. And you're not going to train them in libel. You're not going to give them the nuanced new libel laws. What about copyright infringement, First Amendment? I mean, you're dealing with a serious broadcasting platform here that can do a lot of damage, all right? Also, finally, another benefit of delivering outside expert social media liability training to your employees is that you show the court, the public, and employees that you take social media liability very seriously. So there's just a lot of benefits here. All right, let's move to takeaway number 4. Here's number 4. Never ask your busy in-house attorney to write a social media policy or train employees. Most in-house attorneys would not qualify in court as social media law experts, and this is a specialized area of the law, so obviously your instructor has to be an expert, not just a general attorney. Often in-house attorneys are so busy or lack the expertise in social media law, they unknowingly seek help on their social media policy from trusted organizations. Unfortunately, in a lawsuit, they often pay the price on this reliance because policy gaps are exposed in these boilerplate policies. And mainly it's because of the new federal standards, right? They create these gaps. So also you need to know that there are hidden liabilities and nuances in the new federal standards, as I mentioned before, that require a social media attorney specialist. I mean, here's a medical analogy. If you had a heart problem, you would not seek medical advice from a podiatrist who specializes in foot problems. You would go to a cardiologist who specializes in heart issues. I have a little cold, by the way, so hopefully you'll bear with me. All right. Now, just remember that today's attorneys are specialists. That is why in-house attorneys trust my 33 years of expertise to make sure these policies and employee training complies with the new federal standards. Now, let me just extend this discussion on the need for social media attorney specialists just one step further. If I'm recommending that you don't saddle your overwhelmed and non-expert in-house attorney with the unfair burden of writing social media policies and training employees, You definitely don't want a non-attorney specialist like a public information officer, public relations, and marketing staff writing social media policies and training employees. As stated before, social media involves complex constitutional and civil rights. The last thing you need to do is expose your communications and marketing professionals to negligent training lawsuits or unlicensed practice of law claims, which, by the way, is a felony in most states. All right, finally, let's move to the fifth and last takeaway from the new federal social media policy and training standards. I've had many sleepless nights thinking about this issue. I'm a passionate guy about social media liability, digital media liability, and it's a tough issue. All right, what it involves is public and private sector decision makers and employees who make social media mistakes being sued individually. So let me recap. Not only is the decision maker being sued personally for bad management and not risking this issue seriously, but the individual employee is going to be sued individually too. All right. So in the public sector, the personal liability would be filed under Federal Statute 42, United States Code 1983. And most people in the public sector understand 1983. And in the private sector, personal liability would be filed under common law negligence and other social media related claims. This is not something to fool around with. All right. In both cases, courts find employers engaged in negligence and deliberate indifference to the obvious need for more in-depth employee social media liability training. And this especially applies to off-duty employees using their personal accounts to post opinions on hot-button political and social issues. So look, with so much risk involved, defenses of, oh, well, I couldn't afford an outside social media attorney specialist, or I relied on my model policies, they come from trusted organizations. I can tell you now, that type of defense will fall flat. The defenses will fall flat, and then the courts will just rule your policy invalid. And then, of course, you're going to get nailed for negligence. And it could be negligent training, negligent entrustment. I mean, you name it. They just throw everything on the wall and see what can stick. So as we wind down here, courts have woken up to the permanent reputational damage, harassment, and emotional distress that can be caused by untrained employees on social media networks. I mean, this is a powerful medium here, and you can't under-risk it. The average social media defamation, harassment, and First Amendment infringement case is well over $500,000. There's also a modern trend among federal courts to award large punitive damages that can destroy the finances of an organization and individual employees. Now, remember, the $500,000 is just going to be compensatory damages, all right? Then you have punitive damages on top of that. So for those who are familiar with punitive damages, they're exemplary damages in order to punish the defendant for outrageous conduct and or to reform or deter the defendant and others from engaging in conduct similar to that which formed the basis of the lawsuit. So they're looking to make a public statement with punitive damages, so maybe other people won't get involved in this type of conduct, right? Also, these nightmare lawsuits destroy the public trust in your brand. I mean, people are not going to want to deal with governments or, with the private sector companies who are embroiled in lawsuits. I mean, they'll just go to the competition. They don't want that hassle. All right, so here's the conclusion. That pretty much wraps up the podcast. I hope you found the information instructive. Also, I hope I made a compelling case as to why you must have an experienced social media attorney like myself update your social media policies and employee training. All right. And because you have to make sure they comply with the new federal standards. That's the most important thing. All right. So if you're interested in my online social media liability program for employees and expert policy development that hundreds of organizations nationwide are now using, you can contact me by email or phone, which is listed on my websites and various course flyers. All right. Again, thank you very much for your time. And that is the end of this podcast.